Yeah, that's something that
using Max 6 in the direction of it and the technology for people.
just getting to watch it and just because they might pick you up on the way in. They can just do it now.
So you see,
We can't say that people stop it.
All aboard. All aboard. Good evening, ladies and gentlemen. So, thanks for attending. Tony Phipps is an independent health and safety consultant and specialist. If he wanted to bore you about accidents and other stuff, I'm sure he'll talk to you at length about it. But the reason for this presentation is that we all face a growing risk in terms of business for ourselves and our employees and our visitors to sites in terms of managing health and safety. The legislation is continually evolving, so I think it was worthwhile for us taking some time just to review where the legislation stands, what our exposure is, and to a degree what we can do about it. Over to you, Tony.
Well, good evening, everyone. Thank you, Nigel. As Nigel said, I'm an independent consultant now, but I didn't duck quick enough, and for my sins, many years ago, I was the second safety officer appointed by the Department of Health. Don't ask, it looks as though I might be called back in with this little problem that we've got. But Nigel asked me to talk about a particular subject that I have been extensively involved over the last 3 years and spent considerable amount of time in the coroner's court and in the Crown Court with regards to contractors and the use of contractors and contractor management. And that's what the topic is about tonight, and your responsibilities with regards to contractors. So, contract management. I'm hoping, and I'm not expecting everyone to pick up everything. As you can gather, I lecture fairly frequently. There'll be about 60% of this may stick in, and over the next couple of weeks that'll trickle away. But the presentation tonight is about the engagement of contractors and the range of services from maintenance to major construction that we as companies use contractors for. But the management really is for you as company directors, company senior managers, to ensure that when you appoint a contractor, you are appointing a competent contractor and both parties are adequately informed with regards to that contract. That is a statutory duty. That's the one where it falls down at the first hurdle. I can assure you, court cases I've been involved in, that's always coming up. The recent one, which was the last week in January, lack of management control with regards to regulation for the CDM regulations, that's construction design and management regulations. The company ended up with a £60,000 fine plus £9,000 court costs. The company's insurance has gone up by 60%. Sorry, I meant to do this earlier, I'm going to do this now. Shut that down. Right. So engagement. Do you engage contractors?
Yep.
Yep. What would you classify as a contractor? This is not me talking to you, this is me getting you to think. And I gave you the hint earlier, I do lecture.
It's somebody who does work on your behalf, on the client's behalf, on site.
It's not an employee. That's not an employee.
Hmm?
That's not an employee.
That's not an employer. So it's exactly that. So they could be from anything from a bricklayer through to a cleaner. But the most important is having adequate information, ensuring that that contractor has had the appropriate training. How do we do that?
Unfortunately, by list of CV/experience, that's how much you package a portfolio.
That's all we can do. We can ask the questions, can you prove that information? In some instances, I've got clients asking for copies of qualifications. Certainly when they're playing around with HV, high voltage electricity, because that's something it doesn't forgive very easily. You don't make a second mistake with that. And then cooperation and coordination. Cooperation and coordination also includes information exchange and communication. Very, very important. So getting this lot carried out isn't easy. But if we look at what a contractor is, and yes, you gave the right answer. Contractor is a noun. Person who executes the building or improving of buildings is one. Or a contractor, a person or company that performs specific tasks or services like electrical or plumbing work, carries out cleaning or maintenance operations, or undertakes a specified requirement for a defined period. And how do we define those periods? Contracts, service level agreements.
Task duration.
Yeah, task duration. You get people signed into those. Have you got a legal duty and responsibility when you do that? It immediately opens up a little word called the Health and Safety at Work Act 1974, certainly section 3, i.e. in that, and I will quote verbatim, you are not allowed to endanger the health, safety or welfare of persons not in your employ. Is a contractor in your employ? You gave the answer earlier. No. So you've got a statutory duty immediately from section 3 of the Health and Safety at Work Act, etc., 1974 to give it its full title. And these are just some. The list goes ad infinitum. There is a huge amount of things. Even car parking attendants, vending machines and vending machine operators. So if you could purchase something, purchase a service, and bring that person or that company in to provide that service, they are a contractor. Full stop. I could carry on all night with that. But employing a contractor, I've tried to make it simple, as simple as possible. So when you, as a company, as a manager, as an individual, because some people in companies are given that responsibility of bringing on board contractors, there may not be a director. In Nigel's case, he's got managers that bring in contracted people under his direction to do so. So selecting a suitable contractor, you've got to ensure that they have sufficient skills and knowledge to do the job safely. Professional qualifications is one. Now you may or may not have heard, certainly from a CPD point of view, you've heard SSIP, Safety in Procurement. SSIP is a collective group of accrediting bodies. Now there are over 27 bodies under SSIP. CHAS, you've heard of CHAS, you've seen the signs on the vehicles. Construction line, you've seen those on the vehicles. Safe contractor, I know they're on Nigel's vehicles, because I maintain that for him. Achilles, which is a nightmare to get and very expensive, and construction line. Construction line is the government scheme. Well worth going on if you're doing any contracts for any government body. So that's another way of looking at and making sure they've got the sufficient skills. Because those accreditations, as I say, Chas, Safe Contractor and the like, you have to supply evidences to those accrediting bodies. They then look at those evidences and confirm whether, yes, you can be given accreditation. And that accreditation only lasts for 12 months. So every 12 months it's got to be done again. Assessing the risk of the work. That is a legal duty placed upon you. There's a number of pieces of health and safety legislation that place that duty upon you. Let alone the Health and Safety at Work Act. We've all heard of COSH, haven't we? Control of substances hazardous to health. So there might be substances within your companies that you know about, but the contractor doesn't. So it's your duty to tell them about that. So you've got to assess the risk that that work produces. You've got to look at the level of the risk. The level of the risk. We've all done risk assessments, haven't we? We know what a risk and we know what a hazard is, do we? You do?
Yeah.
I knew you watched the examiner said it did.
So a hazard is something which has the potential to cause harm. The risk is the likelihood of that harm being realised.
Bang on. Well done. Well done. It's exactly that. So harm, a hazard is something that has the potential to do harm. A risk is that hazard coming to fruition. So we need to look at what we're asking them to do, carry out an overall risk assessment. Is there a risk? Now remember, there could be all kinds of things. If you're getting someone in to move furniture within your company, are they going to have to go up and down stairs? Is the lighting sufficient within that area? The looming level sufficient enough? Are the stairs wide enough? Are the barriers in it? So that's just using the stairs. And then you've got well, what are they carrying up there? So you've got to look at the job that you're asking them to do. And the level of the risk will depend upon the nature of the job, of course. So carry out an appropriate and sufficient risk assessment. Again, that's a legal requirement. If you have not done that, you'll be doing what I had to do for a company at the end of January, stand up in court and try and explain why their risk assessment wasn't appropriate and sufficient. The result in this instance was a man fell through a fragile roof and dropped 9 metres and sustained very, very serious injuries. He was lucky he bounced on the handrail of a mezzanine floor 3 metres in, or otherwise he'd have been dead. So carry out an appropriate and sufficient risk assessment. You should already have it in place anyway. I hope you have, because that's a legal duty placed upon you as employers, as companies, to have those in place. If you've not got them in place and something happens, I'll give you my phone number, but it's bloody difficult to get you out of court. Provide information in instruction or training to your employees. Why do you think you need to give your employees information, instruction and training in using contractors?
So ensure their duties are not reposing over.
There's going to be an interface.
Yeah.
Definitely an interface. People will cross over. And the easiest way of doing that is, right, we've got contractors in at the moment, doing this morning, and they'll be working in such and such an area for a number of hours. You are not allowed in the area. Is that appropriate and adequate control?
Might be.
Might be. You then subsequently look at what can we do? Can we lock the doors? Can we lock the area that they're in? Having regard for their safety. So might be. So again, you're doing a risk assessment. You should also provide information to the contractor, because what your employees are doing may affect them. Anyone use a welder or have got a welder within their company? Anyone ever suffered with archi or seen a case of archi? Archi it's very nasty. It's where you get arc welding carried out and the light level is such that it burns the back of the eye and it irritates. It can take a couple of hours to diminish, a couple of days. But archi, caused by one of your employees to a contractor, what do you think the consequences would be?
Silent injury. Lost time injury.
Lost the time for the job, yeah, but it also opens up the opportunity for litigation. You've exposed me. Remember section 3. Setting up liaising arrangements, cooperation, coordination. Information communication is very, very important. It's the best way of controlling anything. Does it cost you anything?
Yeah.
Time,
It's
yeah. Time.
worth feedback.
That's it. I can provide you in 20 seconds sufficient information to develop a risk assessment and appropriate controls. Simple as that. Done it for over 30 years. But information communication is very important. It doesn't cost anything other than time. What it will do is it will save you, 1, the job slowing down, 2, the potential litigation, and 3, ensure that you get the job done properly. I've recently, don't laugh, I do work for the Diocese of Coventry, so I do work for the church. And no, I can't walk on water. But I set up liaison with the contractor and the church. It happened to be a church school. Did we have a problem? No. The contractor turned around and said, I've never ever worked on a job like this or have been given this information and it's run so smooth. All for the sake of just talking to one another. Decide what you need to manage and supervise the work. You have a responsibility to manage and supervise that work. I've had people like yourselves come back to me in the past and say, oh, we have not the responsibility, they do it themselves. No, they're working on your premises. You've got a legal duty and responsibility for their health and safety. You could endanger your own company's insurance, your public liability, because that's where it would come in. Your public liability insurance, not your employee's liability. So set up supervision and how the contractors themselves are going to set up supervision. So you've got that communication, you've got the supervision. Now in some instances I go out and I audit the contractor while carrying out the work. But conversely, like Nigel's company, I go out on behalf of GM Treble and I audit their guys when they are working on somebody else's site. So think of that. You've got to look at the two ways. It's a two-way street.
Tony, at what point do you become a contractor? In other words, if you're doing a survey, you're not in contract.
It could be possible.
Survey.
You're walking around a building,
You were still a contractor.
you're not in contract.
No.
Before the contract.
But that person's building that you're walking around in has got a responsibility for your safety. And in walking in any building, you should be told where there is risks. 9 times out of 10, that does not happen. Right, you can go and have a look at the job and you wander through a workshop. That workshop has got a process in using chemicals. You've got no idea what chemicals they're using. You walk into a cloud that you can't see. You breathe that in. That has happened. I'm going to go through a few of the cases. It has happened. So, just going to do a survey, classify yourself as a contractor, because you do not know the risks on that site. But the person's site that you're going to, the company's site that you're going to, they've got that responsibility to you.
Like if you have a method statement for doing your process, that should be part of that, shouldn't it?
Yeah,
Should be a fundamental part of all the contact details and all other parts. Emergency contacts that you should say when you go to site, ask the question.
yeah, ask the question. Up until the end of this month, there was a yellow card issued by CSCS, CITB. We're all aware of the CITB, CSCS cards. The yellow cards at the end of this month, which is a visitor's card, disappear. I haven't had a word with CSCS yet, Gordon Jenkins, on how and what they're going to do in replacing that visitor's card, because ostensibly it would give people like Nigel who go out and do a survey a base level of understanding from a safety point of view, what they need to do to protect themselves, as well as ask questions of other companies, other areas going in. That now is going to disappear. So watch this space. I'm waiting for information to come back, because I've got a number of other clients very similar to Nigel that go out and do surveys.
Is that across the board, you say? You're saying that's across the board, there won't be a visitor's place?
Across the
Something
board.
will be replaced with something else?
Yeah, it's going to be replaced with something else, so that's across the board. But at the moment, I don't know what it's going to be replaced with.
Well, the actually existing cars, I understand it, are going to continue.
They will continue until the date that they run out.
Because on a visitor's card, normally you expect to be escorted.
Yes. Because you don't know the risks that are on the site. It's as simple as that.
Unless you're on site induction.
But
and all that.
how many times do you go onto a site and you're escorted? Not very often, is it?
Yes. Probably our case most of the time.
But that company, that employer, is actually opening themselves up to all kinds of things. So the basic needs. There's your comments. Does the company have a Consultant approved policy on an underpinning set of procedures that they comply with? It's not very often, I can assure you. A number of my friends have, as you can imagine, health and safety executive inspectors. About 2 to 5% companies that have got that. I know if you did a job at Birmingham University, Aston University, the University Hospital Birmingham NHS Trust, Coventry NHS Trust, Nottingham NHS Trust, Nottingham University and in Montfort, I know one of the things that you'd be given is the contractor's rule book. Why? Birmingham University, Aston University, UHB and Nottingham, I wrote the bloody thing. And it's bang. Those are our rules, that's what you follow. And that forms part of the tender documentation. Again, it's proper control right from the very beginning before you're even on site. So yeah, does the company have a current approved policy and underpinning set of rules? Is there documentary evidence relevant to how contractors are appointed? How good are the tender documents? What do they say? Some of them are as wide as they are long, and you can drive a double-decker bus through them. So evidence, policies, procedures, rules, regulations, are they in place? If you ask that question before you go in, and the answer is yes to them, what's that saying to you? They're aware of their duties, legal duties and responsibilities, and they're trying to discharge them. So you're already on a very good footing. If there's nothing there at all, it's, what am I dealing with here? What are the problems that I'm going to have here? And I guarantee if you're doing a contract for a company like that, you are installing, say, a lift, and they've not got any of these in place. How many times have you had that contract come to completion and you go to do the handover and sign off and no, we're not accepting that, we don't like this, we didn't want that? Again, that without these things in place, it rattles my cage. There is a potential, big potential, but the evidences are all there. Health and safety policies, codes of conduct for contractors, site safety leaflets, the information. If I took you to ThyssenKrupp's, who I've recently been engaged by down in both in Aston and over in Cox's, to do an asbestos survey, an asbestos assessment on the site, you walk in, and the safety leaflets there for visitors to pick up. This is what we're all about, and these are the people that you need to speak to. It works. Very simple. And it's only a piece of A5 paper. Asbestos registers. I've got Nigel's guys, when they walk into a site, that's the first thing they ask for. Is there an asbestos register there? There's about 60 million tonnes of white asbestos or thereabouts in this country. We haven't got a bloody clue where it is. Going back to your lifts, a number of years ago, I got that, you know, the peculiar feeling that you get at the back of your head about the old lifts in the QE that were ready for replacement. I didn't feel right about it, so I had some swabs taken down in the pit at the bottom, and I found white asbestos, and all the back of the doors, all the way up on every one of the floors, had got an asbestos sheet stuck to the back of it to make it fire resistant, and no one knew it was there, because of course the doors open and close.
Most of them lift shafts are excluded from asbestos surveys.
Yep.
Even type 3.
Yeah, because you can't get into them.
We have spent some time escorting asbestos inspectors to do the job.
And there are buildings like that around the country, all over the place.
Just a point about registers. I mean, I had this one experience with a hospital that had a shelf of recent asbestos surveys, all nicely bound, all easy to find what part of the building it was. And it was when a contractor was coming to do a huge steam strip out. I went through it, and buried on the third page of each one in small writing was everything over 2.1 metres has been excluded. So you have to not only know that a document exists,
But you need to read it.
and the client has an inherent responsibility to understand his own document and say this or that has been excluded, and we'll get to it in the future, but you need to be aware it's not in there.
Aston University got prosecuted a few years ago. I got a phone call, Tony, can you come in and help Graham sort this out? The health and safety executive have prosecuted us because we've exposed contractors to asbestos that we didn't even know was there. They drilled a hole above a doorway, and the panel over the top of the doorway was AIB. Hadn't got a clue that it was there. That was interesting. Although the fine was rather paltry, because it was on regional TV and regional radio, it caused bloody ructions. Because contractors were just refusing to go in until they knew exactly where it was. Hence the phone call. Can you help? Fire evacuation policies and procedures. The amount of places that haven't got that is unbelievable. Absolutely unbelievable. Lifting operations and information. Why do we need lifting operations and information? $20-ton snorkel crane. We're going to be driving it into your premises. We're going to be putting the feet out. What will the feet do? Whop. straight to the drains. So you've got to know where all the drains are. Because if they lift, the crane could go over, and anything that the crane's carrying, where's that going to end up? Anywhere. Anywhere. And you are then subsequently putting your employees at risk. Has the contractor got his own health and safety policy? I know the companies that I help, that I advise, have. They're all in place. Contractor induction sign-in sheets, why? Hmm? We want to know who's in the building. That's one of the things that was missing at Grenfell Tower. There was a lot of contractors working on that site, but they weren't signing in on the daily sign-in sheet. Stupid things. Health and Safety at Work Act, both parties, are they aware of their duties and responsibilities? Most important from a company's point of view is sections 2 and sections 3. Sections 2 runs through A to E, so there's subsections within it, and one of them is information and communication, instruction and training. It's there, it's your legal duty and responsibility. Section 3 I've already gone into. You've got a duty to look after the health, safety and welfare of people not in your employ. And then of course your own employees have got duties underneath sections 7 and 8, which I won't go into. But we've got other legislation where other legislation can apply to the contractor. It depends upon what the contractor is doing. Are they a cleaner? If they're a cleaner, they're using cleaning products. What products are they using? The cost regulations come into play there. Are they using hazardous substances? Are you using substances that will interface with the substances that they're using? Anyone ever tried mixing bleach and disinfectant together? They're two substances we can buy off the shelf in a supermarket. Mix the two together and see what happens. But make sure you do it outside, please. Because what happens is the disinfectant is an acid and the bleach is an alkali, and the active ingredient in bleach is sodium hypochlorite. You put the acid into that, the sodium hypochlorite turns into free chlorine, so it produces chlorine gas. Does it mean that the legislation and regulations are not addressed or ignored, that the enforcing authority can take action or is likely to take action? I can guarantee they will do. They will do. They've stepped up. They've stepped up. Anyone heard of the latest? Well, they started issuing about three to 4 years ago. Letters of infringement, letters of contravention. Yeah. Minimum cost is about 500 quid for that letter. Right. You've had a minor contravention. You're not actually breaking the law, but there's a minor contravention. There's the letter for it. It costs you a minimum of £500. That's what they charge you. If you get an improvement notice, that's a bit of a pain in the backside, because the improvement notice says, right, this is what we found wrong and this is the time period you've got to put that right in. And if it's quite bad, you'll get a very short time period, and that's a lot of expenditure. And then there's prohibition notices. You don't want any of those, because that shuts down things until they are satisfied that what they've shut down through that notice has been put right. Quickest I've ever turned a prohibition notice around is 3 days. But that was only on the basis that the inspector who issued the prohibition notice personally knew me and I'd been brought in after the fact. It doesn't happen that easy. Normally a prohibition notice could take weeks to get rid of. So again, the evidence is there. Health and safety policies from a commitment point of view, codes of practice, codes of conduct, CDM policy, asbestos regs. Quite common things, quite easy things to put into place. no problem, if you know what you're doing. If you don't, all you've got to do is find some idiot like me. Roles and responsibilities. Do both the company and the contractor have appropriately qualified and competent people? Well, we've gone through how we can look at those. CVs, accreditations from accrediting bodies. Certainly the policies and procedures would say a lot. And then you've got to look at the roles that those people are playing. You might come in on a Monday morning and you've got one contractor doing the work, and halfway through the week there's somebody else doing that. Ask why. Because at the moment, from a contractor point of view, there's insufficient contractors out there to fulfil the tasks that are being required, that are being asked. And the amount of times I've gone in and I've asked well, what's he doing here? What's his background? What's his qualification? And I found out he's not qualified at all. He's just been told what to do. So we've ended up with an unqualified individual. And the worst scenario that I found was with HV. I won't tell you what I said to the company, but they didn't last more than 20 seconds on the site. So evidences. Again, the evidences are pre-construction information. Anyone doing any type of work, mechanical, construction work, the information is provided by the principal designer. These are the risks, these are the things that you've got to look at, these are the things that you've got to control. So that pre-information's there. If you're not given that, and you're asked to do a fairly large job, step back, ask the question.
Come back to role-based job descriptions for a minute. With generic titles like facilities manager these days, how do you demonstrate competence across the entire sphere of activity that they may be exposed to? Because it's vast.
You can't.
So
it's nigh on impossible.
So how do you answer that question then? Do the company and the contractor have appropriately qualified, competent and formally appointed people?
Right. As a principal designer, and I act as principal designer on a number of, I'm not one individual. I get together a number of people that have got that specific experience, competence, knowledge and qualification, and we act as a principal designer.
Okay, so you have a collective responsibility.
A collective responsibility.
So in that example though, a role-based job description is almost an oxymoron, isn't it?
Yeah. What you need to do is say, well, hang on a minute, there's an area here that I'm really not 100% up to scratch on. So you're saying this to your managing director or whoever.
Yeah.
I need somebody else with that type of skill to come and assist me.
Okay.
And that's the approach that I would advise you to take. Now, we've got an M&E engineer, and that is exactly what you do, isn't it? You bring together a number of individuals. So you might have a mechanical engineer and an electrical engineer working together to perform one contract. And in doing that, you will have been seen from a legal point of view as taking all reasonable and practicable steps. And again, that's a legal requirement as defined underneath the Health and Safety at Work Act, sections 2. Difficult, but it can be done.
I think I probably knew the answer, but it's just interesting with you know, you're the FM responsible for this site. Crack on. And you think, okay, well what's my role?
FM?
Indeed. What does that mean?
Yep.
Okay.
Cleaning comes under FM.
Yeah.
Are you a cleaner? Do you know about all the cleaning products that are out there? The answer's no.
But the duty falls on you, doesn't it?
Yes, the duty falls on
to
you.
To prove that you are competent
Yeah.
in the event that you're being prosecuted.
And your competency there would be to understand your limitations.
Indeed.
And then address those limitations by bringing in another
yeah.
or others as necessary.
Okay.
It doesn't necessarily mean to say that they're there all the while,
No.
but you just bring them in when needed.
Sure.
And if you can then prove that,
Yeah.
God forbid if there's ever an incident,
Mm.
that this is what I actually did, Mr. Inspector, the likelihood of prosecution, or certainly prosecution from that point of view, disappears.
Mm. Always lessons.
Yeah, it lessens it.
Mm.
Risk assessment. They're a legal requirement underneath Regulation 3 of the Management of Health and Safety at Work regulations. Every task, every risk should be risk assessed. That is a legal requirement. Does it happen? No. No, doesn't happen. And it's only when the doo-doo hits the fan, and the first thing that the inspector asks for when they turn up on site is, where's your risk assessments? And if they're not there, it immediately says to the inspector, even your own insurers, ooh, the inspector, they're not compliant to the law, your insurers, oh, we can invalidate the insurance. And that has happened. So has there been a risk assessment undertaken? Identify the risks and the necessary actions to curtail or control that risk. You've all heard of the hierarchy of controls. Yeah, it's fairly simple, isn't it? Eliminate it right down to PPE. That's the last thing that I like issuing. I don't like issuing PPE. And that's, I've been asked before, well, you're a safety professional, why don't you? I'm relying on somebody else to actually use it. That's the problem. And you're the unknown quantity. Documentary evidence, audits. I do audits for Nigel. In fact, recently his insurance company asked me for copies of my audits. No problem, bang them through. Preventative or constructive strategies. Well, what strategy are we going to put in? We're building, well, let's stay with lifts. We're installing a lift. What's the strategy that you put in from a lift point of view? You put barriers up on every floor, don't you, to make sure that no one drops down the hole.
Yeah. Safe system of working areas, and access routes.
Yeah. The other thing you do is stick signs up all over the place.
Absolutely, yes.
So you're screaming at people. Very easily done. Theathella Hellenica, Baracolo. I've just asked you, do you speak Greek?
Yes.
Watch it. I've just said no. Because ne. Okay. Ne is yes.
Yeah, it's a net.
The other thing we've got to take into consideration is not everyone speaks English. So how are you going to get around that?
Visual signage.
Visual signage, pictures, absolutely. Doesn't cost anything. And the visual signage, so long as it's in the international UN colours, and we all know the UN colours, don't we? The yellow, the blue, the green and the red. They're international colours. Stick the signs up, they'll be known. Agree allocations of risk and who's going to monitor what. Right, it's your job, you're going to look at that, you're going to make sure that that doesn't happen within your working area, I'll make sure that that doesn't happen within mine, and where the two come together, we haven't got a problem. Problem solving and disputes. To prevent those things. Again, this all comes down to real good communication. Auditing and inspecting the contractors, I do that regular. Do you do that in your premises? Very important.
Is there a level of competency we should have to carry out risk assessments?
A level of competency to carry out an audit.
No, the risk assessment, to actually produce a risk assessment.
Believe it or not, no. There is no level of competence defined specifically in any legislation. But if you know that there's a risk there, again, staying with cleaning products, and you're using some very nasty stuff, who would be the best person to carry out a risk assessment, cost assessment on cleaning products?
The person that made them,
Hmm?
the company that made them,
A competent.
the company that manufactured that product that you're using.
Yeah, sorry, I'm getting old. The Olara factory gets it blocks the ears up. Yes, so the company that actually manufactures it, we know what we're talking about. It's the material data sheets, and they're all free. So to carry out that risk assessment, you just asked me your level of competence. Are you competent to do that? And immediately you're saying to me that you are aware of material data sheets. You're more than halfway there. So yes, you are competent to carry that out because you are aware. And if you're not, the easiest thing to do is ask. You ask a question. Certainly as somebody like me, just ask the question. Again, it's information communication. Gives you that competency.
What about the audit? You thought the question was that an audit,
Yeah.
carry out an audit, what competency do you need there? Is there any, other than being...
You can actually take a formal qualification in auditing. That qualification, it's quite onerous to get. However, that can be done. But that does not necessarily mean to say that you need that qualification to do an audit. You're having a job done, you know the risks in your own premises, you know the risks that those individuals are doing, you're going around, are they following their rules? Are they following our rules? The answer is yes to both of them, tick. What are they doing? Are they producing any risk? Are they producing any dust, or are they using any chemicals? Yep. Are they controlling it? Tick. So an audit can be very, very complicated, right down to something very, very simple. You can devise those audits yourself based upon the information that you've shared to begin with, the identification of risks from your point of view, and the identification of risk from the contractor's point of view.
A random check is by far and away most effective means.
Very. Do not do it on a regular basis. Random check. You turn up on a regular basis. You'll be here in a bit, so don't let them do that. You just turn up, wander in. Oh, morning lads. Yeah. I guarantee it. It paints a picture. And if you find them doing something they're not supposed to be doing because you've done the random check, it's okay, I'm going to need to do this more often. It also helps with quality. Because you're looking for the job to be done properly. You're looking for an ability to sign the job off fairly quickly without going back with the list of, right, the list of things, the snagging list. I've had snagging lists that have gone on for pages and pages and pages. But you don't want that. You want a snagging list that's fairly short, sharp, because everything's been done properly as the job has been gone through. So contractors and subcontractor claims, do not assume that this will not happen. It is assumed regularly that contractors will not make a claim against their client if they're involved in an accident or an incident. They will. I've had too many cases over well, it's getting to nearly 40 years now I've been a practitioner. But a contractor can and has the right to claim against your public liability insurance. And they will do. this means if they suffer any accident or suffer an accident as a result of misinstruction, misinformation, miscommunication, how do we make sure that we get the right information over and they understand it?
What if the contractor accepts to work on a site that he does not have all the information for anyway? What if the contractor agreed, let's say we're working on a project at the moment where the client has appointed a contractor to build a portal frame, yet he did not want to do any surveys for the ground investigation, and the contractor already dug a hole in the ground and hit a pipe. What do you do in situations like that? Does
That
the-
individual's looking.
But yeah, where does the liability lie? Because I would
The
assume
liability,
that-
the liability lies with the client who actually told you to do it without that ground survey.
But you've accepted the work knowing that they're not providing you with that information.
So that brings into question the competence of that contractor.
That does.
It does, definitely. I agree with that.
So that contractor in themselves, not asking that question up front, should have rung alarm bells.
Yeah.
However, I do know, and it does happen regularly, the clients do not provide all of the information. So in that instance, the information should have been in what's called a pre-construction information pack.
Yeah.
It wasn't there. That is inappropriate. That can lead to a prosecution if someone is actually injured or harmed. At the moment, we've got Grenfell Tower. The architect has recently made a comment with regards to that. He wasn't aware of the fire regulations from the cladding. Now, as an architect, that immediately says, are you qualified? That's something that a junior architect would be asking. So in that instance, it comes back to the client not discharging their duty. In not discharging their duty underneath the CDM regulations, they are very, very clearly defined from a client point of view. The client is required to provide appropriate and sufficient information. If he does not do that himself, he does that through appointing a principal designer, and that principal designer brings together that information and passes it on through the tender documents or passes it on to the principal contractor that's appointed. If something happened, it's the client that's responsible. It's the client that will be prosecuted. If the drainage has hit and it's a main drain, it's the client that's got to pick up the bill for repair. And I've had that with a few instances where they've hit 11,000 volt cables. But there's a question.
It's a near miss, that, isn't it?
Near miss. Well, I had one on the QE where they hit the 11,000 volt cable and they fetched all the operating theatres out. I got the phone call, Tony, we're in trouble. Yeah, okay, I'm on my way over. As the generator kicked in, that was the second question I asked, and the answer was yes, the generator's kicked in. Right, I'm over there. And what we found with the 11,000 volt cables is it snaked. The ground had actually moved it, stretched it. Yet, going across the ground, they'd gone out with a cap detector, and we got big yellow crosses all the way across the ground, every 10 feet. Where this was, it looped out in that 10-foot gap, and bang, theatre's out. So, yeah, they can. So, who is responsible? If you contracted someone or a company to work on your premises and site, you've got a duty. Your insurance should cover those. And the site management's got the responsibility to make sure that they're kept from harm. Coming back to your question, the site management. So, who owns the site owner or their agent or the person responsible for that site. And in most cases, contractors are treated the same way as company employees. That's the way the law looks at them. It's exactly that. That's the way the law looks at them. Do I mention the word IR35? That's opened up another bloody lid for me, and I don't want to go there. So a contractor overall has the responsibility for their own health and safety at work. Coming back to this section 7 and section 8, they've got a responsibility, a duty to look after their own health and safety and that of others who may be affected by their acts or their omissions, what they do and what they don't do. But all companies are legally required to take out employers' liability insurance to cover their employees should anyone suffer any injury. But of course we've got the public liability insurance that comes into this as well. And there are some companies out there that only have employers' liability and they bring on board contractors and the contractors are hurt and they've not got public liability. Oops, is all I can say. Very difficult. Case studies. These are things that have happened. I've got to say these are straight from the Health and Safety Executives Library. You can look at these cases yourself. A tree surgeon felling a branch when it fell into a neighbour's garden, damaging the fence panel. And an hour earlier, the neighbour had been in the garden playing with their 20-month-old child. Close call. The tree surgeon had neither the qualifications to use the chainsaw nor the skill to carry out the job. They're fairly basic things from an arboriculturalist. Chainsaw training. It's 3/4 of an hour. You can go along to B&Q and you can buy a chainsaw and you can use it. It's a deadly weapon. And if you don't know how to use it, certainly you can't see the tip of it, the first 2 inches of the blade when you cut it, there is a high likelihood that you're going to get a kickback. And even Arnold Schwarzenegger can't stop a kickback. I had a young lad, 23 years of age, on the QE site when we were clearing the site for the new hospital. We'd got 163 trees that we'd got to cut down. We'd nearly finished. This young lad had his training at Kew Gardens. That's where he'd come from. National qualification. And he had a kickback and it hit him in his face. Cut a 1/2 inch slash straight out of the middle of his nose and right over his eyebrow and missed his brain by 1/8 of an inch. So someone doing that, likelihood, very. But if the property developer had hired a tree surgeon and he'd been able to check his competencies, and yes, there are qualifications that you can check, very, very simple, we wouldn't have had a problem. So don't assume that someone is competent. Check it, and check again. When I first started this, I'd got 3 inspectors that were my mentors and trainers. And one of the words that Hamish Harper, God rest his soul, because if Hamish turned up on the site, if he didn't get a cup of tea in the first 5 minutes, you got an improvement notice. He got a reputation. But Hamish, tell him again. And tell him a 3rd time because they won't listen. Check it again, check it a 3rd time. So do 3 checks. Quite simple, that one. Case 2. A worker was killed when she was run over by a vehicle operated by a contractor. Went to work in the morning, she was walking around the site that she'd worked on for many years, and a contractor ran her over. Traffic management plans. Very simple, nothing difficult about it. This, Mr. Contractor, is what you're going to do. This is where you're going to drive. This is the speed that you're going to drive at. These are the lights that you're going to have on, flashing or whatever. This is the sound that you're going to make as you're moving around on the site. Very, very simple things. That woman would have heard it. So neither the employer nor the contractor had identified pedestrian routes. Wasn't in the traffic plan, traffic management plan. Additionally, the contractor hadn't given his driver the adequate training to operate it. How many of you have got forklift trucks? No one? You have. And your forklift truck drivers, they're all in compliance with Regulation 8? They've got the training certificates? Yep. No one should be getting on a forklift truck without that training certificate. It only takes a day to get it. But the amount of accidents and incidents I've been to over the years with forklift trucks, and we use those regularly. So the employer should have identified the risk from the contractor in the first instance and set and agreed safe systems of work. Communication, information. Nothing complicated about that one. And a woman wouldn't have lost her life. A farmer who received internal injuries and severe burns from an electric shock. Electricity is something that you can't taste, you can't see, you can't smell, but by God, it does not cause problems. So the electric shock, when he lifted an irrigation pipe connected to a 33,000 volt overhead power line. You can see the power lines. I live out in the country, I've got power lines, I'm fed by a TT system. So all the power lines come down to the transformer on the post. And the amount of times I see the tractors going out into the field and they're doing the spraying and then the arms come up and they are very, very close to the telegraph poles that are march across the field is unbelievable. The employer had not discussed the presence of overhead lines and identified the safe way of moving the irrigation pipe. Quite simple. Power lines there, you see them? Yeah, right. Put it in writing, we let him know. Power lines. You don't go anywhere near those. Certainly you don't go anywhere near them if it's misty weather, because the electricity will jump, and I've seen it jump 6 metres. You get the right type of weather conditions and it will jump. So the employer should have made the contractor aware of the risk that he faced and agreed a method to begin with.
So, I know you said this is from the library. Is this also the health and safety executive's judgment? It's like their words?
Yes.
Because there's a lot of power in that one statement. The employer, you skip the middle bit, it includes the employer identifying the safe way to move the irrigation pipes. 9 out of 10 employers would say it's up to the contractor to determine the safe way to remove them. But that clearly shows that that's not the health and safety executive's point of view.
No. The health and safety executive's point of view is you've got a duty and responsibility. If you can't work out how to do that, your duty is to find someone who can tell them. So going back to what we discussed earlier, make sure you've got that competency, right? We're doing that. There's cables there. You don't lift the irrigation up within 6 metres of that. It's very simple. You can say that, but again, most important, put that down in writing. And both parties need to understand and sign up to that. If the individual then goes ahead and does it, well, hang on a minute, you were told not to do that. It's completely disregarded a safe system of work.
Is it not some barriers or something that's...
Yeah, there's a lot of things you can do. You put a number of posts across the field and you can put the high-vis tape on it. You don't drive with inside that. So there's a lot of very, very simple things. Health and safety is not something that's complicated. It's very simple. And the simpler you can make it, the easier it is for people to understand and actually apply it. You make something complicated and it won't get done, I can assure you. You give people information, safety information that's like the Encyclopedia Britannica, a volume of War and Peace. Are they going to read it? No. A good risk assessment is 2 sides of A4. A method statement, maybe 3 sides. That's it. It should be simple, easy to understand. Nothing complicated at all. And again, you've got to make sure that the individual understands it. Polish?
No,
Lithuanian. I've got a client that's got a couple of Lithuanian employees. And Marta, she's brilliant. Her command of English is excellent. What do? I use Marta to make sure that the information to the other Lithuanian employee is understood. That's all I do. No cost, nothing. But it's done. Very, very simple. And I can't pronounce her surname. Case for a contractor working in a newsprint firm, and he had his leg amputated when it got trapped in the machinery. Printing machinery is very unforgiving. It can be running through at about 2,000 RPM, and to try and get a roller or a stacker slowing down and stopping within seconds, it's nigh on impossible when it's belting around at 2,000 RPM. But he climbed up on a conveyor belt, the moving royal, and he got his leg stuck in the conveyor and it drew him into the machinery. And it was a slatted metal conveyor. So once it was trapped, and there's no way that he's going to get that out because it folds down on one another. And the employee should have identified that there was a risk from working and provided a safe system of work to carry it out. Mm-hmm. Again, it's a dual duty, coming back to your question earlier. That communication, right, how are you going to do it? No, that won't work. This will work. And at the end of the day, you end up with your safe system of work. So if an employer had consulted the employees, this method of work would have been identified. I'm not the fountain of knowledge when it comes to safety and safe systems of work. I even talk to the man, a very important man, that pushes the broom around and cleans up. Because if you've got a dirty workplace, an untidy workplace, it's an unsafe workplace, slips, trips and falls. So I go and talk to the individuals doing the job. Why do you do that? How are you doing that? Where do you do that? Rudyard Kipling had a lovely poem, and I use it regularly when I'm doing a risk assessment. It's very sexist, but Rudyard Kipling was. And it goes, I had 5 little serving girls. They served me very well. What, why, where, when, and how. And then I apply who. And if I answer those 5 questions and who, I've done an appropriate and sufficient risk assessment. It's a good mnemonic. Lovely way of remembering how to do a risk assessment. So what do you need to do? You need to identify the job and all aspects and all the risks. So it's just going over a recapping. Remember, the level of risk will depend upon the nature and the complexity of the work. Some works are very, very simple, some works are very, very complicated. If it's a complicated piece of work, my advice, break the work down. Break it down into easy, biteable chunks. You should provide a potential contractor with the information. That is required legally, certainly, in the construction design and management regulations. That is defined. You should know and understand the performance you expect of them. The way they do it at the universities, contractors rule book. That's what we expect from you. We expect you to follow it. Quite simple, that one. And you could include such information as the job specification. Right, this is the job specification, this is what we expect, how the job's got to be done. You can write that job specification as simply as you want or as complicated as you want. In the job specification, certainly from an electrical point of view or a mechanical point of view, right, where's the tests? What are the test certificates that we expect? How about a contractor getting rid of your waste? What's a very